Hello, my name is Mohammed Safyan and my student ID is 240877884. So, my presentation is titled Advising Haneen on Her Legal Rights and Remedies. This case concerns a dispute involving a sewing machine and fabric bought for Haneen's tailoring business. I will briefly explain the facts, the relevant legal rules, and the remedies that may be available to her. First of all, introduction. So, this presentation considers Haneen's rights in relation to two commercial purchases made for her business. The dispute raises issues under sale of goods law, misrepresentation, and the control of exclusion clauses. I will assess whether the seller breached legal duties, whether Haneen can challenge the seller's conduct, and what remedies she may seek. The key facts. First, Wakar recommended an industrial sewing machine and said it was suitable for customized wedding dress work. Second, Haneen ordered white silk to be cut into 10 pieces, but the fabric delivered was cream and incorrectly cut. She also developed a skin rash after handling the fabric, and later a third party, Knowles Ltd, claimed rights over the machine. The main legal framework. So, the main legal framework is the Sale of Goods Act 1979. Section 12 deals with title, Section 13 with description, and Section 14 with quality and fitness for purpose. The Misrepresentation Act 1967 is also relevant where false statements may have induced the contract. In addition, the Unfair Contract Terms Act 1977 may affect the validity of the seller's no-returns position. The sewing machine purpose and reliance. Haneen clearly explained that she needed the machine for wedding dress customization. Wakar then recommended a specific machine for that purpose, so it appears that she relied on his skill and judgment. This supports a claim that the machine needed to be fit for the stated purpose. It is It also opens the possibility that the seller made an actionable misrepresentation. The nature of the statement. Not every statement made by a seller becomes a contractual term. However, where the seller has expertise and gives a specific recommendation, the law is more likely to treat that statement seriously. Here, Wakar's statement appears more than casual sales talk, because Haneen seems to have relied on it. Her argument is stronger than the statement carried legal effect. The title Swing Machine title problem. The strongest issue concerning the machine is the letter claim by Knowles Ltd. If sister makers did not have the right to sell the machine that would breach the implied term as to title under the Sale of Goods Act. This is serious because Haneen's possession would be insecure. As a result, she may have a strong claim for repayment and possibly damages. The fabric sensitive skin issue. This slide raises two linked problems. First, the fabric did not match the contract because Haneen offered white silk in 10 pieces, but cream fabric was supplied and incorrectly cut. Second, she told the seller about her dermatitis and was assured the fabric was suitable for sensitive skin. Yet, later on, she developed a rash that may support both a contractual claim and a misrepresentation claim. The no-return clause. Sister makers argued that cut fabrics could be returned; however, that statement does not automatically remove Haneen's legal rights. Exclusion clauses in commercial contracts must satisfy the test of reasonableness. If the clause is too broad or unfair, it may not protect the seller, so Haneen can still challenge the non-return position. The remedies and overall advice. So overall, Haneen appears to have strong claims in relation to both purchases. Her strongest claim is probably the title issue affecting the sewing machine. She also has a persuasive claim regarding the fabric because it did not match the agreed description and may not have been fit for her stated needs. The likely remedies included repayment, damages, and rejection were legally available. So here comes the references. Uh, Sale of Goods Act 1979, Misrepresentation Act 1967, Unfair Contract Terms Act 1977, Baldry v. Marshall 1925, Roland v. Devil 1923, Healy v. Taylor 1967, Dick Bentley Production Ltd v. Harold Smith Motors 1965, Oscar Chess Ltd v. Williams 1957, George Mitchell Chester Hall Ltd v. Finstock Seeds Ltd 1983, Stevenson v. Rogers 1999. So here is the end of my presentation. Thank you very much.